Well, thank you so much for joining us all today. We have an amazing panel to talk to, and kind of the purpose of this is, I was thinking about this when I was asked to lead this panel, was I've been in and around this topic of domestic abuse for a long time through my personal friendship groups, but also I'm an HR director, so it often falls at our door, and I'm sure a number of you in the audience come from that world. So it's something that think about a lot, and often think about how are we part of the community response. And I wasn't sure that I would be able to map that out. So when Jess was saying employers are terrified, I was sitting there going, yeah, no, I think that can be me too. So the purpose of today is to demystify that. So we're going to hear from our experts, and they're going to talk us through the journey that if somebody comes forward, that they will go through. And I, when I spent some time with the panel, learned a lot myself. So thank you so much for doing this. But hopefully we will be able to hear from our experts and then take some Q&A. So if any of you are going through and thinking of questions, if I do this properly and manage the time correctly, we will get time for questions as well. But I'm here to learn from this group, and being part of the EIDA organisation and learning so much from the partnerships that we have through that, I absolutely understand that we learn through hearing experiences. So that's enough from me. And what I think probably we'll do is take the time when we're going to give each panelist 5 minutes to talk through their area, if that's okay. And then, but start with introducing yourself, areas of what you do. And I think we're going to be starting with you. Yep.
Thanks, Catherine. Morning, everyone. My name is Andrew Wadey. I'm a Detective Superintendent in the Met. I'm the lead for domestic abuse and stalking, and it's wonderful to be here. Thank you for the invite. The Met is a massive employer, as I'm sure you'll know. It's about 45,000 officers and staff, and we are developing our own policies and how we support colleagues who experience DA. It absolutely affects police officers as well as any other person from any other walk of life. And we know from taking feedback from colleagues who have experienced DA that the organisation's response to how they support them can affect that individual's relationship with the organisation for a very long time. And so it's key that we get it right. So what does DA mean for policing? Well, domestic abuse is a massive driver of policing demand, as I'm sure you can imagine. Here in London, it accounts for about 150,000 incidents per year, translates to about 100,000 criminal investigations. We've got over 1,200 officers dedicated to investigating this one area of crime. Tragically, it accounts for about 15 to 20 murders each year in London, committed by the victim's partner or family member. And in addition to that, many more people take their own lives tragically because of abuse within the home. And serious physical and mental harm is being caused to people every day, and that is the reality. So the impact is huge and the stakes are incredibly, really high. So as a result, risk identification, risk management is key to the policing response, and we work closely with partners and DA specialists to manage risk within the community. However, tackling DA is a team effort. It's everyone's business, and given that we spend a third of our lives at work, employers are key members of the wider team to tackle DA and support victims and survivors. So I thought I'd give you a bit of insight into the key aspects of a police intervention. So the first duty above everything else of the police is to preserve life and prevent serious harm. So when DA is reported to us, either through 999, 101 or through a report at the station, our primary consideration is what action can we take to prevent the risk of serious harm or homicide. So officers use a risk assessment tool, which is a set of questions designed to draw out relevant information about the perpetrator's behaviour. This includes controlling coercive behaviour, stalking, strangulation. So we know if stalking, strangulation, suffocation or choking is a feature of the abuse, then we know that the risk of the future risk of homicide or serious harm rises exponentially, and that absolutely does drive the policing intervention as a result. So that positive action I've just referred to will very often involve the arrest of the offender, and this may happen against the expressed wishes of the victim. and it will often include referrals of the victim to DA support services, and if there are children in the relationship, we will work with children's services to ensure a joined-up response to protecting children. As a secondary priority, but really, really important, is the role of the police to gather evidence and build a case against the offender so that our colleagues in the CPS can prosecute them. The victim will be asked to provide a witness statement that can be used as their evidence in a prosecution, and in addition, officers will gather as much evidence as they can to build a case against that offender, and that can include speaking to wider family and friends, neighbours, and a number of other things, digital evidence. It can be quite intrusive. So
and
I think
Andrew, would you talk to an employer at that point as well?
Potentially, and I think it's one thing to understand is that when a person phones the police for the first time, the DA, or comes to the notice of the police for the first time, on average there'll be well over 20 previous incidents, and so understandably, and you'd expect that would have had an impact on that individual's performance at work, maybe their attendance, the way they present. In fact, there'll be a story to be told there, so there may be relevant evidence within the employer. But I think important to take a moment to consider this scenario from the perspective of the victim who may be an employee, and their world will be upside down, their head will be spinning, obviously. They'll probably be struggling to think further than 24 hours down the line, because that is when the offender is likely to be released from custody. And they've been thrown headfirst into the criminal justice system, which is a difficult and bumpy place to be. So the questions will be, will they support a prosecution? Do they have confidence in the criminal justice system to see it through? Will they allow the police to see their medical records? As I say, it can be quite intrusive. What do they tell their family? What do they tell their boss? And on top of that, they'll be considering their own safety. Where will they live? How do they protect their children? How will they afford to do all of this? So when the police get involved, the victim, who could be a colleague of yours, will be at the start of an incredibly challenging journey, to say, massive understatement, which may involve court proceedings, and probably a good point to hand over to Jazzy from the CPS to pick up the mantle there.
Thank you very much. My name's Jaswant Narwal. I'm the Chief Crown Prosecutor for London North, but I'm also the National Lead for the CPS on honour-based abuse, forced marriage and female genital mutilation, which is a form of domestic abuse. I'm also in charge of all the homicide in London, so really kind of sad that we see many cases which are domestic related coming through, and it's not decreasing. So just to explain the role, because we get a lot of questions around the role of the CPS. We are independent from the police. We are not part of the police. We work very closely with the police, and we disagree with the police quite a bit as well. And we prosecute police officers. I've done a few of those. But we work very closely. But the important thing is we make our decisions, which are set out in legislation, the Prosecution of Offences Act, which states that we can only bring a case if there's a realistic prospect of conviction. And that is a criminal standard, which is a very high standard, as you would expect. And if there is sufficient evidence, it's got to be in the public interest to proceed. That's not usually a difficult decision to make. It's mostly always in the public interest to proceed with domestic abuse cases. So that code for Crown prosecutors is really important. We approach the cases fairly objectively and independently. However heinous the crime, however awful, however emotionally impactful it can be, we have to apply the code. That's only right, because there may be perpetrators, but the law in this country is you are innocent until you are found guilty and proven to guilty. So it's really important we remember that. And it's important when we're dealing with cases, especially as a prosecutor, when we work with the police, we're able to gather all of that evidence, and I'll talk a little bit more about that. The definition's been picked up on, so it's a statutory definition, which is really good, and it covers emotional, physical, psychological, financial abuse between partners, but also between family members. And that's really important to remember. And it's often forgotten because domestic abuse can occur between siblings, It can occur between children on their parents, and we've seen an increasing number of children who are attacking parents, usually their mothers, for all sorts of different reasons. So it's something to remember, because it's not always thought about when that definition of domestic abuse. We often think, and quite rightly, we often think about domestic abuse being between partners. So that's really important. And what are there? About 2 million incidents of domestic abuse. We prosecute about 50,000 of those cases. We're right at the other end. So many of the cases that are reported to you as employers or are investigated by the police don't come through to us necessarily. And there's lots and lots of different reasons for that. So my focus is really when they do come to us, they're usually the serious cases, and it's usually because the police have been able to gather the evidence and the victim has got the confidence to take that case through to the courts. And so it's important to remember there may be disclosure to you for the first time, but that's not the first time, as you know, it would have happened. But it's that confidence that they've had to think, right, I've had enough, I'm going to take this case through. And that's really important for us as prosecutors, because victim attrition is really high, and that lack of engagement is really high. And there are reasons for that. And it also depends on the motivation of the victim when they do report the case initially. Sometimes it's reporting it to the police, as you've heard from Andy, because they do want space and time. They want to be able to move away from the situation, and that's when other services will come in. But victims will take those cases through, and when they do take those cases through, and remember, domestic abuse there's no specific offence of domestic abuse. It's an umbrella term which covers a whole range of different offences. And as we talked about the legislation earlier, it's encompassing more and more offences now. So we've got Section 47 assaults, we've got controlling coercive behaviour, we've got stalking, we've got harassment, and we've also got emotional abuse. So lots of different offences which cover it. When we're building the cases, it's really important when it comes from an employer perspective. I think the question was asked to Andy, do you go to employers and gather evidence?
What practical tips do you have? Yeah,
yes,
exactly.
Really important, because if the disclosure is made there to the employer, you will have got perhaps a first account. That's really important, and that's got to be gathered, and if it's gathered, then it's got to be disclosed as well to the investigators and disclosed. Because if that comes out later when a prosecutor is building their case, it's really hard. It's really kind of difficult because it may undermine the evidence that you've had. And we often have this with cases. So think about GDPR, think about DPA, all of that is really important. And if you've got the consent of the victim to provide that information to the police, provide it, because that's evidence we can then use to build the case. If we don't have cases which we can take to court with the support of the victim, we have what's called evidence-led prosecution. So when you're in a workplace and you know your employee isn't pursuing that case, or they've told you, we can still prosecute the case because we'll look at all the other evidence that we have. We call them evidence-led prosecution. So we mentioned evidence from friends, maybe phone evidence, maybe evidence from neighbours, all of that. As long as it meets that standard, we're able to take those cases through. So think about that. They're still a victim. A case may still be going on in the background, even though they've withdrawn themselves. But in serious cases, we will consider whether or not we actually want to bring that witness to court. Now, that may cause additional anxiety for that employee, because they may be saying, I don't want to go to court, but the police or the prosecution are making me go. That's because we don't prosecute on behalf of the victim. We prosecute on behalf of society, on behalf of the state. And it's really important that we consider the welfare of that individual, but also apply the law. That's what we have to do. We don't create the law. That's what Jess and others do. We apply the law. So it's really important, because if we can still get orders when victims are brought to court. So they may be brought and treated as hostile witnesses, or they're not great terms, unfavourable witnesses, just a legal term, which means that they're not willing to give evidence for the prosecution. And sometimes we have to bring them under warrant because we've had to balance lots of factors, and it's really important. It's not liked, but that's the extreme of cases because it's really important that that victim is not put at risk. The other thing when it comes to courts, probably that's not for me, we don't run the courts, we go to the courts with the cases, is you're aware of all of the backlogs, and the public confidence point is a big point. That's for the politicians to sort out. But that may be one of the reasons that victims don't want to go through, because it's taking quite a long time to get through the courts. Most of our cases of domestic abuse are heard in the magistrates' courts where there is less delay. It's the Crown courts where we've got more challenging, and it may take timelines, it may take a longer time. So it's really important that they do speak to the police, they speak to prosecutors, they speak to third sector support to understand how long it may take, because that's hanging over them. And also remember, there may be bail conditions for the perpetrator. The perpetrator may have conditions not to contact the victim indirectly or directly. Ensure that if that does happen and there's a report in relation to the partner contacting them, they report that to the police. Okay. Because they can be arrested again for that, because that's a breach of bail conditions. And equally, when it comes to orders as well, there may be restraining orders or civil orders in place. If they breach them, some of them become criminal offences again. So that's another offence. So it can be quite complex, but I think it's really important for you to signpost to the police and to the CPS when it comes to this. And we can support victims going through as well with special measures.
So I'm just conscious of time.
Sure.
Is there anything that you want to leave this group thinking about them as employers with, in terms of thinking about those practical points?
I would probably say, if that victim, if that employee is in immediate danger, you call the police. Okay. That's what you do. Even if there is a case in the background, you call the police, because the most important thing is the welfare of that victim.
Thank you so much. We've heard that twice now, so that's a great message. Thank you. Georgina, I think it's over to you.
Yes, thank you. So I'm Georgina Hamblin. I'm founder of my own firm, Hamblin Family Law, and obviously deal with divorce, finance, children, and all sort of domestic abuse angles that come out of that. And so listening to that, it sort of just reinforced my point that I wanted to talk to you about. Is sitting there as employers, I am obviously an employer myself, and you think that sounds quite terrifying. Do you want to put your employee through that? What if it gets taken out of their hands? But I liked Jess's point earlier about really taking it back to being just that first personal support, and seeing it as, a very small step to just have that conversation and make sure that your employee is talking to someone who they trust, who they don't feel like they're going to have to repeat their story over and over again, because a lot of the strain that this process puts on people is that they're required to repeat over and over again the same story, which is really difficult to tell. So it's about getting that right person to have that initial, very personal conversation in the first instance, and not being scared about what's going to follow it. It's so often the case that my clients take the position that they just, as particularly men, because they think that they shouldn't be in a position where they're being abused, if they are, that they don't want to raise their hand and say, like, I can't cope with this and I need help. And so just having a safe space in which they can raise that is just doing an incredible job in itself. So just don't think that this is so overwhelming and you can't deal with it. And a lot of my clients take the decision not to pursue it because they don't feel like they can go through that process. But the police we work very closely with the police and obviously the CPS on where they're involved. But the introduction of divorce prevention orders, domestic violence prevention orders, has been a massive improvement, because it can, where there is a victim who doesn't want to, really go full hog immediately down the court route, right, all guns blazing, there is an option to just have a situation where the spouse is removed from the house. They get sort of up to 28 days to just take stock. Is this what we're going to do? Are we going to go down this legal route? And just have a breather. And the police obviously can support your employee going down that route. So the lawyers should be thinking about it as well, and sometimes the police do it of their own initiative. And I've experienced that being incredibly helpful as just are we doing this? Because the alternative is if you're going down the full legal route, is to apply for a non-molestation order and an occupation order, which is to remove the person from the family home to protect whoever the victim is, and also children, obviously. And so that process takes time, and it's an inherent flaw with our system that it takes, quite a while to get in front of a judge, particularly these days. And then once you've gone once and potentially got an order to remove them, and immediately you have to go back 2 weeks later or 3 weeks later and argue it all again to make sure it's a longer term order. So it's a very involved process. There's repeated witness statements, a lot of interaction with lawyers, and it's all quite a scary thing to think of. So if you take it back to that sort of bite-sized first conversation, shall we just get you some space? Do we need to involve the police now? And don't feel like it's going to get outside of your control. And I was initially going to start, but I got carried away because I wanted to respond to that, was just to say that what sort of typical things do I see my clients do that you might spot as a kind of warning sign that this might be going on at home. And obviously mobile phones these days are a constant sort of feature in people's lives, but you may suddenly just see a change in someone's behaviour at work, that they constantly seem to be looking at their phone, constantly seem to be receiving calls, being dragged out of meetings, not able to attend work functions, not having the money to come to work, insisting on working from home, having their video turned off. All of these sort of small points, but changes in behaviour which make you think something's not quite right. And I think they can be signs that lots of things are going on at home. And Resolution, which is a group of sort of legal representatives and people who are involved in family law, have literally just this month released a report about how we all think that the family courts are dealing with this issue. And 85% of family lawyers are basically saying that the courts aren't doing enough to recognise financial control as a form of abuse, and sort of then following that through and it having an impact on the outcome of a financial dispute. So there is a huge amount of financial and economic abuse going on, and I think that's probably something that employers can spot, quite easily if they sort of think personally about who they're working with and what their experience of them are day to day. So I just don't think of abuse as naturally, looking out for bruises and somebody coming in and crying all the time. It's literally can just be so systemic to just their entire way of life. And it includes not being able to see their children. If you're suddenly hearing someone saying, oh, my wife or husband or any sort of partner is preventing me seeing my kids, that can be parental alienation, that can be abuse. So just think wide angles, and have those conversations and be discreet about them, because the last thing someone who's suffering this wants is their entire workforce knowing what's going on and asking them questions and everyone saying, are you okay? Like, they need their trusted person, and they need that person throughout, and that person to be recommending organisations that can help them outside of the court arena. And if the legal advice is needed, they need to act quickly. Because as horrible as this sounds, if you had an incident happened more than a few weeks ago and the person is delayed or spoken to you about it for a while, and it takes some time to think about whether they're going to do anything about it, you can end up getting to a court and them saying, actually, that's not recent enough, and you've basically sort of acquiesced to the point that obviously you're not really scared, and so we're not going to give you an occupation order. So it has to be that you get your ducks in a row, help them get their ducks in a row in the smallest possible way. It can be like just making sure they've got a family member, someone at home. Where will they go if they have to get out quickly? Who will they call if they've got no money and they've got no access to their credit card? Can you pay them in a different account for a period of time? Right. Can you, it sounds, somebody said earlier, I think on the recording, it's not just about giving them time off and saying, okay, now get back to work and nose down to the grindstone again, but it's about sort of bigger changes and being aware that this is not something that's just there's going to be an incident and then it's going to go away after a few weeks or months. Typically the family court process can take hate to say it, but a year to 18 months to deal with all of the wrapping up. And if there has been domestic violence, that first month is going to be really intense, and there's going to be lots of different meetings, talking to the police, talking to lawyers. They're going to need flexibility around work, but it's not just for that period, because you then have your sort of another month later and a return date hearing, and then beyond that the children, and then the financial process, and they're all separate, and each bit is challenging.
Takes its time as well. So
yes.
So thank you. Is there anything you'd like to kind of share with? I mean, you've given us great tips there. So thank you for that and being practical.
Yeah.
Is there anything you want to kind of leave us thinking about?
Yeah, I think the big thing is that you're going to find that the person doesn't really want to pursue it. I think it's the same thing that you were saying, that and that's okay in that first conversation. If they don't, that's not the end of your responsibility. Keep checking in with them, but not in a pestering way, but in a sort of, I'm a solid, reliable person, and I'm going to keep being here for you, not just like right now and I've ticked a box and it's done.
Great, thank you. Over to you, the MOJ, and you're also an EIDA ambassador, is that right?
So I'm wearing two hats, I guess.
Yeah.
Head of change delivery in HMPPS, but an EIDA ambassador. And that's the context in which I want to speak to you today. So I thought it'd be helpful perhaps to give a brief timeline of what that actually looked like and felt like, the engagement with these different services, and then talk a little bit about the impact of that, practical, emotional, physical, and most importantly on the children. So I guess, like a lot of victims, I wouldn't have labelled myself as such, despite a lot of evidence to the contrary. Until it became kind of an inescapable truth, and I found myself on a Monday morning ringing my boss from outside my children's school to tell him that I wouldn't be in work because my wife had been arrested for assault, and I needed some time to sort out the practicalities. So from that point in February 2015, the onward timeline of engagement with the services that are represented here today, I think it was about 7 years, really. And as colleagues here have talked about, very intense police involvement at the start, leading through really to the criminal conviction in November 2015, with sporadic engagement after that as post-separation abuse layered in between family court proceedings. The criminal court itself, an aborted hearing in July 2015, followed by the actual final conviction in November 2015. So, huge stress in July as we built up to that, and then the disappointment that nothing could happen because evidence hadn't been shared, and then through to conviction. The family court, 3 separate sets of family court proceedings lasting between 8 months and 2.5 years, and financial proceedings, which took probably about 8 months too. So all told, about 7 years with different layerings and combinations of those interventions. So how did that feel? And what were the impacts, I guess? So at a practical level, there were incidental sort of issues, such as the fact that the police need my phone for evidence. So in the first couple of weeks following the assault, I didn't have my phone. Then really the biggest one, time, just all the time for appointments, solicitors, CAFCAS, court, emails, phone calls. When I was represented myself 1 week, because I represented myself in a number of the family court proceedings, at one week I received around 80 emails, which isn't a full-time job, but it's a significant, chunk of work to deal with. And a complete lack of agency around the demands on your time. None of those proceedings were initiated by myself. I was the respondent in all 3 of those hearings. So I had really no control of the direction of travel. It was a constant sort of response to demands placed on me. Financially, I don't like, it's sort of a sense of vertigo looking down, trying to cost up what the family court proceedings cost, but I would say a conservative estimate of around £70,000. If you're in divorce proceedings, obviously there's that genuine threat that you may not be able to live in the house that you're currently living in, and that you and the children may not be able to be resident there. If there's financial abuse, the likelihood is that will continue beyond the separation in new and different ways, perhaps withholding child maintenance, etc. But emotionally, incredibly tough. That trauma recovery in the early stages, that sense of relief with disclosure, but equally that sense that in disclosing you've removed your armour and you're now vulnerable in a way that you weren't before. I was advised very soon after the assault by Bernardos, who were working with the children at the time, that my abuser would not go quietly, and that was very much the case. They circumvent orders, they push boundaries, they use family members as proxies, and time and time and again, it needed police intervention. They'll also use proceedings perhaps as a lever of control. I left the criminal court in November 2015, and in the space of walking back to my car, had received 2 emails from my ex-wife's solicitor, basically telling me that she would be returning matters to the family court and the financial court. So no sense of relief or at all, straight back into the next thing. I think the proceedings themselves, by their very nature, are confrontational. You're at a point of extreme vulnerability, fragile self-esteem, and your parenting is completely under the microscope. I was told very early by my family court solicitor to have a thick skin, and that's quite a difficult message to absorb when your skin is literally still bruised and broken. And the physical aspects of that, naturally, when there's that demand on your bandwidth mentally and emotionally, there is a physical outcome. I think it was somewhere in the middle of the 3rd set of family court proceedings that I developed shingles, and my wife very sensibly said, I think it's probably time we found the money and got some representation, because you are literally, it's breaking you. But I want to just, if I can, just finish off talking about the impact on the children, because they are so often overlooked in these matters. But the impact on an employee of supporting their children through this situation is enormous. In a nutshell, they basically exemplify and amplify all the practical and emotional challenges. So at a practical level, you're desperate to maintain normality. I had a phone call the morning after the assault from the police saying, you need to bring your daughter in to give evidence. And I said, well, but I've got to get her to a swimming lesson. And she said, a swimming lesson in half an hour. I said, I think you need to forget the swimming lesson. But you're so desperate to not, disrupt their lives with this additional trauma. But then on top of school and extracurricular activities, you now have social services appointments. CAFCAS wants to see the children. Psychologists need to see the children. Support service wants to see the children. You often find yourself trying to make those arrangements yourself, trying to get them the support they desperately need. So you're having to navigate commissioning agencies, GPs, school nurses, and then you've got to get them to the appointments. There were, for my children, around 17 different interventions. And I think for my daughter, that has meant that she has since talked about the family court proceedings as being as damaging as the abuse that she suffered at the hands of her mum. I think, basically, domestic abuse sends absolute shockwaves through their childhood. And as they mature, they confront and they re-engage with that trauma in the context of the developmental stage they're at. So the children at the time were 4 and 7. Right at that point, it was fear, abject fear, not wanting the light off, wanting doors shut, little visitors at 2, 3 in the morning, crawling into bed next to my son, moving his belongings in, and saying, actually, I'm going to stay here for a few months, just putting his things on the bedside table. Later, it was frustration at being different, being called out of lessons to talk to CAFCAS or another psychologist and have the same conversation that they'd had a number of times before. And now, for my daughter, her first serious relationship, and that abject fear she has that she will tread in the footsteps of her mother and that she wants to be different, and how will she ensure that she has healthy relationships moving forward. I think, sadly, also they are often the levers of the control. They're exploited, basically, for their proximity to the victim and the capacity that then brings to continue to hurt.
Thank you for sharing. That's very, very moving. Thank you. So I have been a terrible chair, and we will have no time for questions, but it's all over to you, Susie, to take us through to understand this a bit more from your context.
Thank you. I often find myself talking directly after somebody who's experienced something very difficult. So I'm sure I'm not the only one who feels quite sad, but thank you. So I should just gather myself and pretend I'm a BBC reporter out with a roving microphone. So I'm the chief executive of a charity called Tender, and our purpose is to prevent domestic abuse and sexual violence. And our mission is to equip every child in this country with high quality relationship education, because we're here hearing about these terrible stories, and even just listening to them is very traumatic. And we want to change the script. We want to be able to hear different stories and stories of positivity. So the majority of the work that Tender does is with children and young people in schools, looking at the notion of healthy relationships and their rights and responsibilities, to the friendships and, as they get older, the intimate relationships that they will have in their own lives. We're not talking to young people about what might be happening at home. That's for other specialist services to do very well. But what I want to talk to you about is the work that we've been doing in workplaces as a consequence of the work we do with young people, which is around taking a preventative approach to looking at the issue of domestic and sexual violence. So where there is a lot of focus, of course, on the crisis end of the issue and how systems can be put in place to support victims and survivors of domestic abuse. What we're looking at is working upstream. So how can we work with businesses to enable them to create a culture where people feel confident to be able to have conversations about domestic abuse? And I think I'm probably going to repeat quite a lot, particularly of what Georgina said, and I won't repeat, but you know, in terms of the tips and the ideas that she was talking about, those are things that we talk about with workplaces when we're delivering training with them. And also repeating what Jess was saying earlier as well. So I think, you know, hearing the same messages is really important. We're all on the same page, and actually for employers, it's not rocket science. It doesn't have to be overcomplicated. You can create a culture where people who are experiencing abuse can seek support, but you don't have to be specialists in what that support looks like. So from our point of view, we're looking at working with businesses in order not to be able to prevent domestic abuse. That's not your role, but you can create an environment where you can protect employees who may be experiencing abuse. So the workplace can be somewhere where an employee can get help from specialists if they want to, so they can go into a private room, make a private call, or access websites. And we've done a lot of work with Lloyds Bank, and actually one of the key things very early on was, because there were so many firewalls, it was very difficult for them to be able to, for employees to be able to access the kind of helplines and websites that they needed. It's important then that those individuals can stay employed and therefore be financially independent. So those are really key things that an employer can make sure that they can put in place for their employees. By creating a network of support, they're really sending a message to everybody that domestic abuse is something that's taken seriously. So for victims and for perpetrators, it's an issue that is important to the employer. And it's about normalising the conversation, so people aren't worried about, oh, will I cause offence if I ask something, or will I make a situation worse if I intervene? So the key things are, across the employment group, everybody has a good sense of what domestic abuse is. So it's not somebody turning up with a black eye. It's actually, as Georgina said, a change in behaviour. Maybe they're not going to social events. Maybe they're not turning up at work in the way that they used to. So look for small changes. Thinking about one's attitude. So victims of domestic abuse are hypervigilant to people's attitudes and places of support. So if somebody says something like, well, I don't know why she just doesn't leave, you know, she's always going back to her partner and she says that he's abusive, it can't be that bad. Thinking about changing the question and the mindset. So actually, rather than why doesn't she just leave, what are the barriers to her being able to leave and to be able to leave safely? And then effectively responding, so making sure that there are posters on the backs of toilet doors which give a little definition of what domestic abuse is, and then some helpline numbers and a room in the place that you can go to. And then in terms of the work that we do with employers around children and young people, often there will be family, parent carer networks. We work with those so that parents or people who are connected to children and young people can have those conversations about healthy relationships and equipping those young people so the next generation of workers with the opportunity to understand what their rights and responsibilities are to healthy relationships. So we're looking at generational change. So as Jess said, this is going to take a long time, but it can start in the workplace and it can start in schools.
Thank you. Thank you to our panellists. I hope that was helpful. And for me, I learned so much from you. I really appreciated it. But I think what I definitely heard is we have an important role to do as employers, but there is help. We don't have to be the experts. So thank you so much.